Good evening and welcome to the third of our lectures in the Modern Advocate lecture series for 2019. My name is Stafford Shepherd and I'm Director of the QLS Ethics and Practice Centre. I wish to acknowledge the First Nations peoples on whose land we are meeting and who are the custodians of this land, the Turrbal and Yagara people. I wish also to pay my respect to their law women, law men, to their elders past, present and emerging, and thank them for their practical wisdom and sound judgment. My function tonight is to ensure that you are going to be safe. So if I could ask you to please listen carefully to the following instructions. 1, if you wish to ask a question, you can use our slido.com. If you go to the website and place into your browser slido.com and also use the event code QLS Events. You can ask a question in this manner, and if you like any question that you see, please like it and it will be more prominent in the questions that I can ask of our guest speaker this evening. Alternatively, you can do it in the traditional manner, and that is raise your hand and a member of our staff will bring a microphone to you to be able to ask the questions. Questions will be asked at the end of the presentation. In the case of fire, there are 2 areas that you can leave, and they're both next to the lifts outside. Would you please go to King George Square, where there is a meeting place, or alternatively attend where our staff have instructed you to do so. By attending tonight, you'll receive a 0.5 in the CPD, and please note as well that you will receive feedback forms tomorrow, and I do ask and encourage you to complete those forms because this allows us to be able to present to you better events into the future. There will be networking drinks on the conclusion, and they will be in the members' lounge. Again, could I ask you to remind yourself that you can use slido.com and use the event code QLS Events. It's my great pleasure to be able to introduce the President to introduce our guest speaker for this evening. Thank you.
Let's see if you're awake. Good evening, everybody. Oh, come on, we can do better than that. Good evening, everybody. Yes, that's much better. Welcome to the Modern Advocate Lecture Series. We developed, actually that's wrong, Christine Smythe developed the Modern Advocate Lecture Series when she was the Deputy President in 2016. And she did so to provide a forum for young lawyers to get expert instruction in advocacy, but more importantly to meet and liaise and form associations and friendships with other young lawyers, other young barristers as a means of building both collegiality and collaborativeness within our profession. Now, I've just stolen an idea, so let's see if I can try it out on you guys. Any of you folk, have you ever heard of this character called Harry Potter? Okay. No, I'm not going to do a Harry Potter impression. But following up from Harry Potter was this thing called Mythical Beasts and How to Find Them. Do you remember that? Well, I'm told that's what it was. And when, and here's the slick segue, so see if this works. The world of advocacy is full of mythical beasts. And one of the things we have to firstly find them, and then we have to train them, and then hopefully tame them. So let's think about it. What are they? Well, of course, we know the rule of law. It's that chicken in the corner of the yard that we feed and ensure that we're all safe under its spreading wings. We become aware of the rat, the reasonable alternate theory, case theory, the rat. And that's a great advocacy animal. And then there's what Her Honour Justice Elizabeth Fullerton of the Supreme Court of New South Wales used to refer to as the Dumbo elephant on a high wire piece of advocacy. And of course, what she was trying to conjure up with that particular image was something heavy and ungainly, something that could fall at any moment. But when it's carried off, with incredible aplomb, with great balance, and you get to the elephant gets to the other end of the wire, everybody is amazed at this mythical beast. So advocacy is one of those beasts that sometimes we don't know what it looks like until we see it. We think we know what it looks like. We think we know its dimensions. And like the mythical person who gets to describe an elephant, the blind man, have you heard of this? The blind man is told to go and describe the nature of an elephant. So one blind man grabs the leg of the elephant and says, the elephant is like a tree. Another one grabs the elephant's trunk and says, the elephant is like a big snake. Finally, another blind person just grabs the ear and says, the elephant is like a winged butterfly. Now, it's all the same thing, but it's what we conjure up from that. And I just simply want you, as you listen to Her Honour's speech tonight, to see what mythical beast is being conjured up in your mind, what high wire steps that you can take to success. And of course, like all things, you don't get anywhere without practice, you don't get anywhere without passion. So we hope that this is going to work for everybody tonight. This series, it was said, particularly by some down south, wouldn't work. They said that young lawyers would not be interested in it and wouldn't turn up to that sort of thing. They were wrong. Because, of course, the Modern Advocate Lecture Series goes from strength to strength, and largely because all of you support it. And it really does give us a boost when members of our noble profession get behind these types of lectures. One of the secrets to securing that support, of course, is the quality of the speakers, and our speaker tonight makes a significant addition to our distinguished series alumni. Judge Hampel, SC, is a judge of the County Court of Victoria these days, but actually started as a humble criminal lawyer, much as I did. The difference is, of course, is obvious. I'm still a humble criminal lawyer, and Her Honour has gone on to bigger and much better things. Judge Hampel has long been committed to equality of opportunity and involved in human rights and civil liberties associations. As the Commissioner of the Victorian Law Reform Commission, she made recommendations on the reform of defences to homicide, to sexual offences, and access to assisted reproductive technology. Her career has long defined the kind of courage that we aspire to as advocates, that determination to do what is right rather than what is convenient, and to hold fast by the rule of law. Remember that chicken we were talking about? To hold fast by the rule of law no matter what. The courage is one of the reasons that I'm very glad Her Honour has been heavily involved in another of the Society's important offerings, the Solicitors Advocates course, and I cannot thank Your Honour enough for your efforts in that regard, which have made our members much better equipped to service both their clients and indeed the rule of law. Now, this may, I hope, be of some interest to you because Her Honour's non-law interests, and it's the things you don't know other than the public-facing person that make us all interesting individuals. So I'm told that her non-interests include skiing, surfing, and so I understand, welding. So, before anyone arcs up, oh, terrible. I always try to get one dad joke in at least if I can. I'm going to hand over to our eminent speaker tonight, Her Honour Judge Felicity Hampel. Would you please welcome?
Thank you very much for that introduction. The welding, I'm afraid, was a relatively short-lived career. I was actually quite frightened of the welding machine. And whilst I like to think I'm a brave person generally, the welder and I just couldn't get the power balance right, and it always seemed to have the upper hand. So I dream of being a sculptor, of being able to find old metal and make it into things, and maybe one day if I can work out the right sort of fireproof suit, I'll take it up again. But meanwhile, skiing, not something to think about here so much, but something I'll be doing tomorrow when I leave here, is a passion and one of those things that does help me put some of that life in the law into perspective. But I want to start, if I can, by letting you in on a secret. Judges talk about advocates. Just as you may want to know who the judicial officer is, who you're about to appear before, we want to know who's appearing before us. And just as you talk afterwards about what they were like, so we too talk about what you were like. And just as you ask what they're like, if you haven't appeared before them before, we ask what someone's like if they haven't appeared before us before. And just as you feel that sense of dread or pleasurable anticipation once you know who it is you're going to appear before, we too have that same feeling of anticipation or dread as we come from that back place that you don't really know about and onto the bench of the court. So, what I want to talk about tonight is what you can do to encourage more of that judicial pleasurable anticipation and less of that sense of judicial dread when your name is the one on the appearance slip that's conveyed to the judge. And when I talk about pleasurable judicial anticipation, I'm talking about the sort that actually means looking forward to being understood and assisted, and not from the prospect of being able to have a good yell at someone who can't yell back, bringing out the worst of our bullying capacity. So what I want to do is welcome you into the world of the Australian Advocacy Institute. I see some faces here who I think have been to some of our workshops lately. We are absolutely delighted that this collaboration between the AAI and the Queensland Law Society has generated such interest and has led to so many local practitioners coming to workshops and sharing their passion and enthusiasm and their desire to be better at what they're doing. So I want to welcome you into that AAI world, because that I see is a place where any aspiring, fledgling or fully fledged advocate can gain an insight into what makes a good advocate and how to help you make yourself an even better one than you already are. And in the process, I hope too that I'll imbue you with a little bit of passion, a little bit of that passion to be the best that you can, and to use your skill to make a difference. So to help you make it easy for the judicial officer to understand what you're there for, what you want, the material on which you rely in order to support what it is you're asking for, and why they should make the orders that you're seeking. To understand that as an advocate, the court must not only understand what you want and why you want it, but how to deal with the competing considerations, what's to be put up on the other side, and what the answer is to the other side's arguments or submissions. To help you avoid hearing questions in that often plaintive tone, like, "Why are you telling me this?" Or phrases like, "Everything that could have been said on behalf of the applicant has been said, and more than once. But," and you know there's something terrible coming after the but "I must also take into account what was put on behalf of the respondent, or the community interest, or whatever else." Something that means, that but means you're going to lose. I also want to talk to you about how to make it hard for a judicial officer. Hard to avoid making the right but courageous decision. Hard to make the safe but unfair one. And at the end, or underlying all of that, to earn the reputation of being trustworthy, committed, well prepared, succinct, and always on point. Modest aims, you might think, and tested by earning and maintaining that reputation even if you lose the case that's before the particular judicial officer. So how do we make sure we achieve those modest aims? Well, it's important to ask that because, of course, we can't always measure our success as an advocate by the result And I say our success as an advocate because although I've been a judge for 14 and a half years now, at heart I think I'm still an advocate. You can't get that out of your system. I was a barrister for 25 years and it's something that just never leaves your soul or your spirit. It took me about 10 years on the bench before I could actually say I was a judge rather than say I was a barrister and have to correct myself. It just, I think when it's in your blood, it's in your blood. And certainly the teaching of advocacy has given me the passion to keep on thinking about being an advocate. And every time I get up and do a demonstration when I'm teaching advocacy, I have that little sense of, maybe it'd be nice to be doing that still. And then I think, oh, well, maybe not. Maybe it's better for the enthusiastic, bright young ones who haven't got that veneer of cynicism that I seem to have developed over the years. And maybe it's better for the bright and enthusiastic ones to make me crack that veneer of cynicism so that I can start to believe in confidence in human nature and humanity again. But let me come back to where I digressed from. You can't always measure success by the result. You can't choose the facts, you can't choose the side you're on, and you can't choose the law. Unfortunately, someone else, either Parliament or some pesky appellate court, has already said what they think the law is, and we've got to work within it or around it rather than directly change it. Unless you finally got to that lucky stage where you can go to the High Court and explain to them why they should change the law in the way that you're suggesting and have them say, but yes, of course, tell me how to do it, and have them eating out of your hand. Everyone's dream, no one's reality, but it's nice to dream. So, of course, having said that you can't always measure your success, how good you are as an advocate by the result, it does go without saying that if you win a case, it's because you're brilliant. And it's only your brilliance that has brought about that result. And if you lose, it's not your fault. The witness let you down. The client lied. The law, the facts, or the judge were just against you. The dog ate your homework. You knew when you got dressed that morning it was your unlucky suit. Or you should recognise there are some days when you wake up, you should just close your eyes and go back to sleep again and not get up. You know, the sort of things we all go through when we've lost a case. But it's no longer accepted wisdom that good advocates are just born that way, that you're either good or you're not, you're either going to have the talent or you won't. And it's no longer accepted wisdom that with experience, you too can become that good advocate. So, although advocacy is often defined as the art of persuasion, and it is an art, it's one of those arts that cannot flourish unless there's an underlying, although at its best, unobtrusive mastery of technique. So what I want to talk about tonight, what I'd call a 15-minute masterclass in the AI theory of best advocacy, is this, that advocacy is a series of developed skills and techniques. That although talent or fluency plays some role, increasingly research shows that talent plays a lesser role and hard work and learning from that hard work play a much greater role in your skill and your success as an advocate. So for those who'd never thought that they were particularly good at orators, take heart. For those who do think they're good, understand you've got a natural advantage, but if you coast on that, you're likely to be overtaken by those with the greater diligence because they don't start off with the same high level of expectation of themselves. That's actually borne out by research. It's not just me being cynical. Suits my theory, though. So, in the AI world, we say that advocacy is a generic set of skills. That whether you're practicing in the magistrate's court or in the High Court, whether you're doing witness action matters before a tribunal, or whether you're dealing witness actions before a jury in a criminal context, the fundamentals are the same. And whether you're dealing with a commercial case where all of the evidence seems to be in documents written in very dense form and in very tiny font, and where witnesses seem to have little to do with anything, the fundamentals of good advocacy are the same. It's how we translate and transport them from one task or one forum to another that makes the difference. So what we say in the AI world are 3 fundamentals of good advocacy. You'll think when I say them, this is a warning, you'll think when I say them that you've wasted your time coming here tonight because they're so obvious. But bear with me and let me flesh them out, and I hope that they will have a bit more meaning than the relatively simple words that I use to describe them convey. The 3 fundamentals are these: preparation for performance or the understanding of the trial process, and communication. Now, it's pretty obvious. No doubt you've been told many times before, go and prepare. Go and prepare for your performance. Understand the trial process that you're involved in and communicate well. If it were that easy, nobody would struggle with their advocacy. No one would want to do it. You could just say, yeah, I'll communicate well. I will. I'm a great communicator and I will continue to be so. And it'll just work. I'll prepare. And I'll learn the trial process and then I'll be ready and prepared for my performance and that'll be it. Would that it were so easy, but it's not. So what do I mean by those? Preparation first. Preparation means it has 2 main components to it. The first is the simple part, time-consuming but simple. It's simply the acquisition of the requisite knowledge. That means knowledge of all of the facts. And this is deep knowledge, not superficial knowledge. It's not knowledge that comes from a skim reading of the witness statements and the pleadings. It's knowledge that comes from a deep and profound understanding of what everybody says and what every document says and what every plan shows about the matter. It was an enormous relief for me when I discovered that lawyers, particularly judges and barristers, have very high levels of obsessive-compulsive tendency. Because until then I'd been sort of embarrassed about it and sort of tried to hide it. But once I realised that I was not alone, that there were many other lawyers who did, and it was that obsessiveness about precision, about detail, about order, about knowing where things were and always having them where you could find them, trying to think things through in a logical fashion and following that train of reasoning. It's what makes us good at what we do. It makes us really difficult sometimes elsewhere, as no doubt our family members have shared with us, or the newcomers to the office who haven't yet picked it up sufficiently. But it is what makes us really good at what we do, because we're obsessive about the detail and the information. So knowledge, first of all, of your facts, really deep knowledge. So when someone says something, you know it's not right, or it doesn't come from that source, it comes from another source. We should be good at that because to get through school and university, there's got to be a fair level of cramming, of putting that knowledge into your head, or these days at least, reading it so that you know it and learning to store it maybe on your iPad rather than in your brain, but in a way that is easy to find, easy to retrieve, and stored in a logical fashion that makes sense to you. So that's the first part of knowledge of the facts. Then there's knowledge of the relevant law, both statute law and case law. Again, it can be time-consuming, but it's well within your skill set. That's what you've been trained to do. But it's fundamental, not only because you need it for the next stages of preparation and the next fundamentals of advocacy, but because it's one of the things that gives you your credibility with your court. It gets you that reputation for being trustworthy. If you're not right about the law, if you're not sure of the particular statutory provision or where it is in the statute or even what statute it is, you lose your credibility with the court. And so they're going to have to check everything you say themselves. And so that knowledge, that good knowledge of the law as it applies to the particular case, not the law generally, is also essential. The third aspect of this knowledge is knowledge of the procedure that governs the particular jurisdiction in which you're operating or the case comes in, and the procedure in that particular part of the application that you're doing, whether it's a compulsory conference to try and settle pre-trial, or whether it's the witness action, or whether it's a directions hearing or something before you get to the trial stage, or whether it's post-result argument about costs or the effect of ancillary orders. It's knowledge about the procedure that governs that particular part of the application. Again, that gives you confidence, and it gives the court confidence in you, and it gives you authority in the hearing room. People will look to you as the one who knows, and that in itself is an enormous confidence booster. The last part of knowledge is one that is particularly important to criminal lawyers, not always so well known or loved by lawyers who work in other jurisdictions. In fact, sometimes I think quite unknown to lawyers in jurisdictions other than crime, and that's evidence. There is a thing called the Evidence Act, and there are actually rules that apply in some jurisdictions as to whether evidence is admissible or not, and the conditions upon which it's admissible. And if you're in a jurisdiction where evidence matters, you need to know the evidentiary rules. Has Queensland picked up the Uniform Evidence Act yet?
We have it at Commonwealth level, Your Honour, but not at state. We remain deeply committed to the Commonwealth.
Victoria was much slower than New South Wales, the ACT and Tasmania and the Commonwealth to pick up what Victorians still call the New Evidence Act, although it's the Evidence Act 2008 for us. And we call it the Almost Uniform Evidence Act because it's not entirely on all fours with the Commonwealth or the New South Wales version. But having been a common lawyer myself, I must say the Evidence Act is a thing of beauty. It's got this absolutely beautiful, simple test. Evidence is admissible if it's relevant. As simple as that. And evidence is relevant if it's capable of bearing on a fact in issue in the proceeding. So simple. That's section 55. It's just so simple. And after that, it's a matter of weight, which is really what people have been doing in non-criminal jurisdictions, as far as I can work out, no matter what the common law or other evidentiary rules are. Let it in and we'll argue about it later, and it's going to be a question of weight. But no technical steps about proving hearsay, no technical steps about proving business records, and some very simple and fair requirements for written application if you're going to adduce or seeking to adduce evidence that's hearsay, for example, or if you're seeking to adduce or to use evidence for a particular purpose, such as to support tendency reasoning or coincidence reasoning, or to support an argument that there's an implied admission in what was said by a person. So if you don't have the Uniform Evidence Act, think about lobbying for it, but meanwhile, do at least acquire some knowledge of the Queensland Evidence Act, because even when people say the rules of evidence don't apply in this jurisdiction, every so often they do, or decision makers decide they should apply the rules of evidence because there's a bit of evidence that's important, and so they think it's the fair way to do it. So you'll get stuck if you don't know. So that means even for those of you who think you're in an evidence-free zone, knowledge, at least a working knowledge of the rules of evidence, is important. But if all else fails, even if you don't want to sort of confess to someone you've looked at the Uniform Evidence Act, just talk about relevance, and relevance bearing on the likelihood of a fact in issue, or bearing on proof of a fact in issue. So, simple as that. So that's the first part. That's the knowledge part of preparation. It takes time, but it can be done. And the more you do it, the more you work out efficient ways of doing it, acquiring the knowledge. And for that knowledge that you're going to need again and again, like the substantive law or the procedural law or even evidence law, you can acquire it and keep it so you can retrieve it in a way that's easily able to be re-accessed, so you can make more efficient work processes rather than have to learn it afresh or check it afresh each time. Just check for changes because they happen. So that's the first part. But once you've got the knowledge, you've got to do something with it. And so the second part of preparation is analysis, that working out what all of that information that you've got means. It's no point simply standing up before the court and showing that you know your pleadings, know what's in the witness statements that you've filed, know what's in the other side's witness statements, and know the law. It's how you're applying the facts to the law, to the outcome that you want. That is the important part of the analysis. So analysis has a number of aspects to it. The first is, first of all, identifying what it is you want, whether the law permits you to get there, and whether you've got an evidentiary foundation to get you there. Again, I know it's sort of blindingly obvious when it's said, but sometimes we get so caught up in mastering the detail that we actually forget to think too much about that. And that's what generates these, why are you telling me this sort of questions that sometimes come from a court. So the analysis is, what do I want to achieve? Does the law permit me to achieve that? Can I do it within the procedural and evidentiary framework that exists in the jurisdiction? And do I have the evidence to support it? That's stage one, if you like, of analysis. Many people think that's enough, but it's not. Stage two of the analysis is, what's in the way of that? First, are there weaknesses in my evidence, in my proofs? Are there problems with my interpretation of the law that means I may not get there? Do I have evidence to support all of the points of proof that are needed in order to get the outcome I have? Is the evidence strong enough? Is the witness likely to be credible and believed? Is there anything else I might need to show that what this witness says is correct? Is there anything supportive that comes from that witness or from another source? So that's the next stage. That's still essentially the analysis of your own case. The third stage is analysis when it comes to what's against me. And this is the part that's often left out. I know what I'm going to say, and if I say that, I should win. But what's against me? What's the other side going to say? What do they have in terms of evidence that might undermine my evidence or challenge it, and might mean I can't achieve my end if their witness is accepted instead of mine? What do they say about the law? Is there a competing strand of authority? Is there a different cause of action or a different way of framing it that might point to a different outcome? How do I deal with what's against me? So that's the second, or if you like, the third part of analysis, the other side's case. So what do they have? What are my weaknesses that I see by reason of that? And what can I do to address them? Or what answer do I have to what they're going to say in opposition to me? And that really brings me to the second plaintiff question, or the second plaintiff judicial comment that I referred to earlier. Everything that could have been said in favour of your proposition has been said, but it doesn't take account of this. And this is not just talking about first instance work or lower court work. Sir Anthony Mason, in one of his fantastic talks about appellate advocacy, had a complaint about advocates in the High Court who asserted very well what the moving party's proposition was, but were not quite so good at setting out their reasoning process as to why that was so. They seemed to think that because they said it was it, whereas the High Court seemed to think that they said, because they said they should tell them why they thought it and what supported it. And then, even if they got them to the why they said they were right part, it was much harder, Sir Anthony Mason said, to get many of them to, and what do they say to the other side's argument, and why is their argument preferable? So it works all the way up the hierarchy, not just at first instance or witness action level. What's the case against me? What's my answer to it? And therefore, at the analysis stage, what else might I need to do to get more evidence to support my case, or what arguments can I come up with? What's my approach to challenge the other side's evidence, so as to say where there's a conflict on the evidence, my evidence should be preferred. So that's the analysis stage, if you like, and that's where we come to developing what we in the AI world call the case theory or the case concept. So what's your case concept? It's the end product of the analytical process that allows you to identify what it is you're contending for, how you're going to get there, what's in the way and how you're going to deal with that. So It's sort of a very simple set of questions or tests, but absolutely essential to keep on bringing out, because the analysis is an iterative process too. We might start with the analysis thinking we're heading over here. We might then analyse our evidence and our material and think we may fall a bit short, and there's a real barrier over there in the other side's evidence that we're going to find difficult to overcome. So our next stage of analysis might be, is there another way of getting to the end we want? Or is the end that I first identified as the thing I was contending for the only way to get the actual result that I need or that the client wants? Can I pitch it a bit lower? Can I ask for something different? Can I frame my case in a way that this evidentiary conflict no longer has to loom as the central issue? Is there a way that we can analyse it to go a different way and around that? So the analysis keeps on going. So you may end up ultimately with a case concept that's different from the one you started with. You may end up analysing a different sort of relief that you want that will still essentially give you or your client what you want, but you're going to get there a different way. And so then that means explaining that to the client too and taking them through that process. Or it may mean withdrawing some of the case or changing tack, admitting some things and confining a fight to other things. The ability, therefore, to give the hard advice to the client about what is actually achievable, not just saying, you tell me to fight, I'll fight, which is not always the most helpful thing for the client. So that's analysis, the case theory, and the second part of our first fundamental. Now, having said that, one of the best ways, I think, to do the analysis is to, first of all, pretend you're on the other side. Because if you analyse the other side's case, you're much more likely to see the strengths of it and then to be able to identify them as the potential weaknesses in your own case. If we analyse our own case first, we tend to get wedded to our own analysis, our own case, and the strength of our cause, may overstate our strengths, understate our weaknesses. So if you analyse the other side's case first, it often means a more clear-sighted view of your own case. Makes it a little schizophrenic, but it's very helpful. The other way to do it is to sort of set yourself up, or if you're working in a team on it, to divide yourselves into this is the applicant, this is the respondent team, and argue each point out amongst yourselves so that you take one side, say, well, this is my strength, what's the counter-argument, and get someone else to do the counter-argument. And then if you run out of people, you take it home and you do it with your family until they run out of patience. And then when that happens, you do it in your head. Left brain, right brain. Left brain, right brain. It's one of the reasons I'm a lawyer. Adding up's not very good and directions aren't very good either. But, so work out, just do the argument in your head. I say this, what's the counter-argument? They say this, what's the counter-argument? So you've threshed the arguments out and you've threshed the points out so that you're familiar with them. But don't try and do it just from one side because it tends to lead to a somewhat blinkered view. Ultimately, though, you are going to have to settle the war in your own head or the war within the teams within the office and bring them back together and say, well, now we've sorted that through, what are our strengths, what are our weaknesses, what's our answer, where are we going, are we agreed on this as the end point, are we agreed on this as the path to get there, are we agreed on this as the way to deal with the obstacles in the way. So, easy, isn't it? Anyone can do that. 10 minutes and you've got the analysis part and the preparation part done. What's the next part? The trial process. Having done the analysis, the next thing is what we call preparation for performance, because the knowledge and the analysis are all about the how to go about preparing your case, preparing for the advocacy. The preparation for performance, the working it through into the trial process, is, if you like, the what to do as opposed to how to do. So how, when we've done that analysis, do we turn that into each of the separate advocacy tasks that are required in any particular case? So if we're working on a traditional witness action case where we'd have an opening, Evidence in chief, whether it's oral or whether, as is increasingly the case these days, it's written, it's still evidence in chief if it's a witness statement or an affidavit, and should be thought of that way, drafted and structured as evidence rather than as a proof or a statement or an affidavit. Then we've got the cross-examination of the other side's witnesses, and then we've got final argument. In the UK, they talk about final speeches. We like to say final argument because it is an argument. It's a summing up, not a summarising of the evidence, but a summing up of what the propositions are that you're contending for, and the evidence or process of reasoning or legal analysis that supports the propositions that you're contending for that lead to the result that you want. So in those stages of the trial process, each one requires a different type of preparation for performance because each of them involves different skills. An opening is telling the court what it's about in the first place, or, as my friend Philip Dunn says, poisoning the well. Telling the story in a way that will implant your version of it in the mind of the decision maker so that that becomes the sort of means by which everything's tested after that. Telling it the story of the case, the narrative of the case from your perspective in a way that will make it sound right and fair for the outcome that you're contending for, and gives enough information about what it's about. So as you move into the evidentiary phase, the evidence comes in and supports or reinforces what it is you've told the judge or judicial officer it's about in your opening. So it's the narrative storytelling and able to weave it all together rather than having to do the boring chronological, these are the pleadings, my first witness will be X, this is what she'll say, my second witness will be Y, this is what he say. What a waste of an opportunity when you can tell the story. So that's your opening, the story of the case. Your evidence in chief is clearly the main evidentiary foundation of your case because you should be relying on your own evidence primarily to prove your case. And so it's the way you get from your witnesses that evidence that you need in order to prove what it is you need to prove to make your case, and in a way that makes logical sense and in a way that makes your tribunal think this is likely to be true. Either the evidence itself is likely to be reliable or the witness is likely to be truthful and therefore the evidence to be accepted. So it's the adducing from your witnesses that which you need in order to prove your case. Which brings me back to witness statements. There has been a terrible tendency around the country and around the world to produce witness statements that are no longer the words of the witness and that no longer seem to relate to what ultimately have been defined as the evidence relevant to the issues in the case. Lawyers draft witness statements and they tend to put them in lawyers' words, lawyers' phrases, lawyers' conclusions. And so often, when witnesses are cross-examined about something in their witness statement that's contentious, you'll end up hearing the witness say, well, I didn't say that, that was the lawyer's words. It may be right, it may not be, but whatever has happened, it means the witness has walked away from what's in their witness statement, and there's just this little hint that maybe you put it in there rather than the witness that may affect your credibility as well. And they often contain enormous amounts of irrelevant information because somebody's drafted them who's not the person who's done or at a stage when the analysis of the case and the development of the case concept was not done. And so it contains information presented in a way that doesn't relate to the issues or doesn't relate to how you want to present them and where you realise your main points of proof and your points of persuasiveness need to be. So I'd really like to urge people to think hard and long about how witness statements and affidavits are drafted from now on, and to think of them as written evidence in chief rather than a big list of everything the witness can say that bears generally on the topic. And think of it in terms of, if I were leading this as oral evidence, what would I need to get from the witness? What's the order in which I'd need to get it? And am I ensuring that I'm getting from the witness facts, not conclusions? Because that's what evidence is. It's facts from which conclusions are later drawn by the tribunal of fact, or from which you contend in your argument at the end, conclusions can be drawn that support the end you're contending for. So that's evidence in chief. Easy, isn't it? Anyone can do that. Cross-examination. Cross-examination is not a time to explore the other side's evidence by asking the witness what they really meant about something. It's not an opportunity to examine crossly. Let me let you in on a secret. And this may resonate with your life outside practice of the law. How do you get the most cooperation from people? By yelling at them or by speaking politely to them and nicely and respectfully? How do you let somebody know that you know what they know and get them to agree with it? By sounding accusatory or by getting them to confirm something that you both know? You get much more from people by being nice to them, by being correct, accurate, and respectful than you are ever going to get by yelling at them. And let me let you in on another secret. There's this sort of transformation that happens when we walk from the bar table and suddenly sit up on the bench and look down at the bar table. And that is, the bar table is the working place of the lawyers who occupy it. And because it's their workplace, it's an area they're familiar with and comfortable with. It's their language, it's their rules, it's their capacity, subject to what the judge is allowed to do from time to time or decides she wants to do from time to time. But the lawyers do a lot of the running of and the shaping the case. You bring a witness in, they're out of their power zone. Doesn't matter whether they're a really powerful person in the outside world or whether there's somebody who's never been in a courtroom before and they're terrified. It doesn't matter whether they're a doctor talking about their examination of a patient, whether they're a professional witness like a police officer, or whether they are somebody who witnessed a motor vehicle collision and they're an independent bystander, or they're a victim, a complainant of in an assault case, and they're talking about something that happened to them personally and that's deeply distressing. It's not their comfort zone, it's not their power place. They're quite disempowered. The rules are rules they don't understand. The form of getting information from people by the formal question-answer process is very different from the way we converse with people and get information from them generally. It's a very disempowering thing. So when we as lawyers stand there and use lawyer language, make in-jokes, and use, whether consciously or unconsciously, our knowledge and familiarity with the court and the process, witnesses can very easily be overborne. And particularly if the manner is aggressive and unnecessarily so, given the sort of information that's sought to be obtained from the witness, then even if a cross-examiner gets concessions from the witness, the court may not be prepared to accept that they were genuine concessions made with an opportunity to properly reflect rather than something that was bullied out of them. And therefore you may not have the witness's answers in cross-examination accepted and standing for the propositions you're hoping for because of the unfairness in the process that led to that. So think about that in the context of cross-examination. Answers that are adverse to a witness's interests that have been elicited in cross-examination are much more likely to be accepted as being a truthful and genuine response, or a response that they had to give in a fair fight, than if there's been an overbearing or a sense that they have been overborne in it. So there are still ways of maintaining control, still ways of showing that a witness should not be believed or accepted, of demonstrating the witness is partisan, but it doesn't have to be by yelling, and it doesn't have to be by aggression. Just think of how you deal with having to confront someone in life outside a courtroom. And I don't mean when you're angry with your partner and you're having one of those unedifying yelling matches, but rather when you're trying to talk to a work colleague about something where you've got to reach a common ground and there's been a problem, or resolving a dispute between kids, as who hit who first in the sandpit. And the sort of techniques you use there, come on, tell me about it. Now, you can't do that. Yep. Well, I know you said you didn't drop the plate, but you were standing there with it at your feet and the cake was in your fingers. So it really was you, wasn't it? Yep. You're much more likely to get the kid to say, well, yeah, I was just frightened, than than if you yell, because other people are saying, no, I didn't do it, because they're terrorised by then into maintaining the denial. So remember, we're human beings as well as lawyers, and bring that into the courtroom and into your preparation as well. So that's cross-examination. What is cross-examination? Or that's what it's not. What is it? 3 purposes and 3 purposes only for cross-examination. Sometimes there is information that the other side's witness has that you know they have and that you know they are likely to have to reveal, that is helpful to your case and that can safely be elicited from the other side's witness. So that's getting affirmative evidence in cross-examination to support something you've identified in your case theory you need to have and can come safely from that source in cross-examination. So purpose 1, something affirmative for your case. Purposes 2 and 3 are to deal with those things that are in your way, the negatives. And where you have to deal with a piece of evidence that is, if accepted, contrary to your case and will mean that you can't get up. So something that is an impediment to you otherwise proving your case. Witnesses can say lots of things you don't like, that your client doesn't like, that your client may disagree with, but if they don't matter to what you need to prove in your case or what you have to get out of the way in order to prove your case, they're irrelevant. So again, that comes back to the Uniform Evidence Act test of relevance, relevant to a fact and issue in the case. If it's not relevant to a fact and issue, you don't have to worry about the conflict. But if there is a conflict, you've got to deal with it. It can be dealt with in 2 ways. First, by challenging the evidence itself, and second, by challenging the credibility or the truthfulness or the reliability of the witness. So either you're a liar and you've got an interest in this and you've made up your version in order to suit your own interests or because you hate my client, challenging the credibility of the witness, or although you now say that the traffic light was green when the car went through it, the statement you made to the police at the scene and the one you confirmed the following day said that the traffic light was red. So you've got a prior inconsistent statement to confront the witness with, and therefore can be used to challenge the evidence itself as to what colour the light was, rather than saying the witness is not to be believed. Okay, so that's cross-examination. 3 simple, short purposes, and usually means it's very brief. And final argument I've already touched on, it is just that, an argument. It's not merely a summary, a repetition of what's already been elicited in chief or cross-examination. It's not simply an assertion, but it's setting out your reasoning process, letting the judge or the jury into your mind so that you spell out for them what supports the propositions that you're contending for and why they should be accepted, why this witness should be preferred over that witness. So you being Queenslanders, you'd probably prefer what we call the Kevin Rudd approach to argument rather than what we'd call the AAI general approach. The Kevin Rudd approach is when you state a proposition, you ask yourself the question, why do I say that? And then you answer it. Remember how we used to do that all the time? I wouldn't necessarily recommend answering at the length that Kevin Rudd did, but when you state a proposition, it's a pretty good test to say to yourself in preparation, why am I saying it? And to make sure you tease out your process of reasoning. Because you've done the analysis, it'll make sense to you, but it may not be as clear to the person who's listening to it and hearing you explain it or hearing you state the proposition. Or you can do the south of the tweed approach, which is to put a because on the end of the sentence. Witness X should be preferred over witness Y because that forces you to set out your reasoning process, the facts or the reasoning process on which you rely to support that proposition. So the because test or the why test, to make sure that you're not simply asserting an argument, but you're setting out the reasoning process. What follows from that too is an argument. It's generally best to state the proposition you're contending for first, and then to set out the matters that support it, rather than start from the bottom and set out all the evidence and say, therefore it points to that conclusion. It's much easier for the listener to evaluate the force of each piece of evidence or the reasoning process if they already know where you're contending for. Just makes sense, doesn't it? And so that leads me on to the last part of the trial process, which is the order of preparation and our preparation for performance. We start backwards. We start with preparing our final argument. Because after we've done our case analysis and developed the case concept, we know where we're going and we know what we've got and what we need to prove in order to get there and what we've got to demolish and why we should be preferred. So that's the final argument. We've got the end point and the identification of what we need on the way. It follows from that the next thing generally that we prepare is evidence in chief, because that's the evidence, that's the factual foundation for the arguments that we're putting at the end. And generally, it's your own evidence that's going to support your case. The third thing we prepare is cross-examination, because by then we're pretty clear about what's in issue and what's in the way of our proofs being accepted, and therefore what we need to deal with or demolish from the other side's argument, and what other little bits we might need from their witnesses to support our case. And so the very first thing you do, the opening, is the very last thing you prepare, because until you've gone through those other stages, it's hard to say what the story of the case is and to detail the narrative to the court. So that is the nutshell. The last bit I've left, and I'll just deal with very briefly, and that is communication. You can do all of that work, but if you speak too fast, if you can't read your notes, if you're using legalese, if you're not thinking about the needs of the listener, if you're not thinking about speaking in language that can be understood by a witness, if you can't be heard, then all of that work is going to be for naught. So communication of being able to properly get this across in a way that is empathetic to the particular case or person you're dealing with, that deals with both sides, not just your side, that is authoritative because you've got everything at your fingertips and because the OCD means you're incredibly, impeccably prepared, every page perfectly lined up in your folder, every tab just where you need it, every document just in order as you know you're going to get for it, because you've already visualised it before you've done it. Then you're going to be able to communicate it well, and that in itself gives you an authority that otherwise is very hard to have. So it's, funnily enough, it's not just saying, I'm going to be authoritative or I'm going to be confident. It's doing all of those other things that give you the confidence so it comes from within rather than something that is external. So that's advocacy, AI world in a nutshell, the three fundamentals. I just want to say a little bit to finish off with, to take it somewhere a little bit higher. Sometimes, even with all of that, we're not going to win. But this, well, I hope, will lessen the prospect of losing the unlosable and make the idea of winning the unwinnable sometimes something that you can do. But we can't always measure our success by the win or the loss, and we can't choose the side. Sometimes there are real concerns about what we're doing is worthwhile or whether we're finding it meaningful, whether we're on the wrong side or whether the law's so manifestly unfair in the area that you feel you're part of a system that perpetuates injustice rather than creates justice. And that can be really difficult. There will be times in your paid work where you may question the justice of the outcome or the broader social utility of the particular law that applies. And sometimes you need to take a longer term view about where that plays out in our legal or in our social landscape. So it's really important to have that perspective, not just about the particular case, but about what you're doing and how you feel about it more generally. Sometimes it is a longer term view. I want to finish with a lovely story. Years and years and years ago, when I was a barrister, I appeared for 3 young girls. They were 14 years old and they were playing Australian rules football. They'd grown up through Auskick, the little kids kicking program, that cuts out at age 12 because anti-discrimination law said that you could not have sex-segregated sport for kids under 12, but over 12 you could. Interestingly, the origin of that law was to encourage girls to play more sport at a young age because studies had shown that even from at primary school, girls were not participating in sport as much as boys. So it was having mixed comp was seen to be a way of getting more girls in, because boys' sport was actually better organised too, much more being put into it. So having mixed comp rather than setting up a girls alone competition was seen to be a good way of drawing the girls into the established thing. The unfortunate byproduct of that was a lot of sporting clubs then had stopped girls being allowed to play what had previously been a mixed sport once they got to 12. And there often weren't girls' sporting events or sporting teams in that thing. And that was happening with AFL football, which is, the big sport in Victoria, as you probably know, for winter. These girls had played all the way through Auskick and kept on playing with their suburban teams, who were more than happy to have them continue to play because they were good players, and because they'd been playing since they were 5 and 6 with the same team, it was all very normal. It wasn't a boy-girl thing. There was none of that sort of gender silliness that can often happen as kids get into adolescence. So these were just people on the team. And so it had been a fantastic thing. Clubs were all completely relaxed. Someone up in the hierarchy of the league suddenly saw that there were girls playing and said, we can't have that. I was told later, privately, that in fact their insurers were worried that they may not be covered. And they were saying extraordinary things like, boys who in a tackle might be charged with sexual harassment. I kept on saying, what about Hopewati? Because that case just happened at the time. Or they'd say, remember the AFL footballer who got testicular cancer because he was knocked? Well, girls might get breast cancer. I said, cancer of the breast doesn't actually occur from a bump? It was woeful ignorance, but nonetheless, these girls were stopped from playing. So we ran an anti-discrimination case because they came to me. I said, let's run the case. And at that stage, you could sex segregate sport for over 12s and for adults, provided there was a relevant difference in strength, stamina, or physique between men and women that would have made mixed competition unequal. And again, that was supposed to be remedial to allow women to have a competition where women could win, rather than and stopping men swamping women's comps, rather than stopping women who could play on their merits in a men's comp from playing. Anyway, so we ran this case. We won the battle and lost the war. We were able to show that there was no relevant difference in strength, stamina, and physique in boys and girls up to the age of 14 that affected the way they played AFL football. And we had these fantastic, photos of great, big, beefy 12-year-olds, standing beside tiny little prepubescent 12-year-olds, and still in the same age-ranked team. And showing, of course, the difference in strategic thinking that 10-year-old girls had compared to boys. So the boys would bash through the pack and get the ball, and then they'd kick it anywhere. The girls would sit back, look a bit more carefully, get the ball and kick it in the right direction. Generalising, but that was the sort of stuff, because you did have to generalise. However, by the time we got the result, the girls had turned 15. So they were not allowed to play. And I will never forget walking out of the tribunal, and I was trying to explain to the girls we'd won, but it wasn't going to affect them. And one of them sat down in the street, and the cameras around, and sat down in the gutter and cried. I was standing there with these 3 girls, because they were just gorgeous, comforting them and saying, let's see what'll happen. Fast forward 15 years, AFL started AFLW, and it was a roaring success in Victoria in terms of the first season of women's footy. The crowds that turned up surpassed anyone's expectation. But one of my 3 girls was 29 and still playing football, and was selected to play for Collingwood in the first season of the AFLW, and walked around, did every interview she could, telling the story of what had happened in this case. So she couldn't keep on playing in the mixed comp back then. She was able to at school because her school would let her play, but there was no teenage girl competition then, and there was a very limited grown-up women's comp that wasn't generally appropriate for 14 and 15-year-olds. 15 years of hard work, it played off, and suddenly there's this spectacular success. Penny played in the first season, and she's now the junior coach for the Collingwood VFLW, and she's got a career as a football coach. It's a lovely story about you might win the actual case, but you can keep on advocating for change and inspiring other people to advocate for change. She talks with such pride about being part of a case that made this open for other people, and understanding what litigation was about, and inspiring girls to play footy. And this is what you can do sometimes. And that's what I mean about making a difference. It happens not just for your paid work, but in your unpaid or your pro bono work, in advocating for change in a broader context than in a particular case. There are lots of ways of being a good advocate and making sure that you are able to make that difference, not just to make judges think you're a better person, but for you to feel really good about what you're able to do to make a change for individuals or that broader good. So that's advocacy for tonight.
What a great story. What a wonderful story, because it really fits in with the theme of tonight chosen by Your Honour, that is making a difference. Sometimes as advocates, we don't even realise that we've made a difference. We might have lost a case, we might have won a case, we might have lost the case and then won it 15 years later. But one of the most important roles that we have as advocates is to have courage, to advocate for what we believe is right, and to have the courage not to advocate sometimes for things which we know are wrong. And sometimes arguments just simply need a time to come for them to be made real. Tell you a quick story. One of the things that you might often have heard me talk about is the Albert Einstein quote about those who have the privilege to know have the duty to act. And it's a very, very important phrase, because that's how we make a difference. You get a law degree, you work hard, you become an advocate, you stand between the state and the individual, or you stand on behalf of a plaintiff or a defendant, or for whatever cause that you may be arguing for. And it is one of the great honours to be able to do that. You mentioned Kevin Rudd. I suspect I'm the only person in this entire room who's had the somewhat dubious pleasure of cross-examining Kevin Rudd. Remember Kevin?
Hold him to the answer.
I'll get to that. Years ago, Kevin, back in April 2007, went to the first National Labor Conference as the leader of the opposition and soon-to-be Prime Minister. And he came out with this fabulous phrase. He says, "My name's Kevin, I'm from Queensland, I'm here to help you." And the reality was that the rest of Australia laughed, but not for very much longer. So we fast forward to about 5 years ago. We had the Pink Bats Royal Commission in Queensland, and I was acting on behalf of a family whose 16-year-old boy had died on the job, having received no training, having worked for 2 days, and having been issued safety equipment, namely a pair of Crocs, and a metal pole which he poked around on the roof of a house to try and put the metal bats down. Unfortunately, there were live wires all the way through the roof, and the inevitable occurred. So we came to cross-examine Kevin Rudd, who was represented by the great advocate Brett with 1T Walker from New South Wales. So it was a weird room because I was the only solicitor advocate, and I sat there patiently waiting my turn. And of course, because I'm only a solicitor, I had to go last. So I had to listen to 8 Silk, 4 juniors, and then finally myself. So I knew what I had to do, I knew what I had to ask, but I just didn't know how to make it interesting. And I asked Kevin, something, not provocative, something like, how does it feel to have blood in your hands, something non-controversial. And Kevin said, "That's a very good question." And then he said, "But the better question is this." And then went on to cross-examine himself for the next 20 minutes. And he was the most impossible witness to cross-examine because, firstly, he either didn't understand the question or understood it all too well, was able to answer questions in such a way that you didn't have a clue what he bloody said by the end of it. I mean, who's ever heard of programmatic specificity? You know, unbelievable language control. And the end result of it was that you were frightened to ask the next question, because the moment you then said, okay, so you feel terrible about having blood on your hands, and he'd then go on and answer a better question for the next 20 minutes. But the wonderful thing was that halfway during my cross-examination, we had a break. And I kid you not, a man wearing a pink beanie, a pink tutu, and a very long beard all the way down to his navel, which we could see, quite disgustingly, turned up, did a handstand, and then walked on his hands past Kevin and I, who were just sort of standing there looking at him. And I thought that was the most honest statement that I'd heard during the entire cross-examination. So I just want to thank Her Honour very much. There's a guy called Charles Hamilton Houston, who was a great African-American lawyer in the 1940s and the 1950s. And he was a person who, having argued his case, would then jump into a car with his colleagues and then speed off straight after the conclusion of his case, generally followed by carfuls of hooded mobs in hot pursuit. And that showed an incredible bit of courage. And he said this, he said, a lawyer is either a social engineer or a parasite on society. So, watch this great segue. This then leads to the next bit of courage, because advocates have got to have courage. And as proto-advocates or experienced advocates, you now get the opportunity to show a different kind of courage, and that is asking questions of Her Honour. And of course, we remind you of Slido, and I'm sure Stafford will talk to you about it. So ask questions. This is a great opportunity. Be part of the great continuum that is advocates. And could I ask you, before we start asking Her Honour questions and cross-examining her, and before she answers the questions that she really wants to answer, could I ask you to join me again by putting our hands together and thank you for a great presentation. And I'll leave it to Stafford.
Thank you, Your Honour, and particularly thank you for your talk on making a difference, because as part of our society, we believe in good law, good lawyers, and for the public good. And that is the story of making a difference for our community as well. So thank you once again. I have two questions from Slido, and then I'm going to throw it to the floor. What is the most common mistake that you see our early career lawyers making in the courtroom?
I think probably the most common mistake is getting bogged down in detail and not having a clear picture of what it is they want to say and what it is they want of the outcome. And that may be sometimes a lack of confidence, a fear that if you say straight out what it is you're trying to say, that either the paucity of the thinking behind it might be exposed, that, people undermining their own confidence in themselves and unfairly, or they haven't actually thought it through, and so they're not able to articulate in a sentence or two what they're heading for. So we get a lot of detail and not much precision about where we're actually going. So again, that comes back to stage 2 in preparation, the analysis and the development of the case concept.
And do you believe that there is any difference in techniques when we are making submissions before a judge or before a jury?
Well, you're talking to a different group of people. When you're talking to a judge, they've got legal knowledge, they hear evidence and read materials differently. Jurors are not trained lawyers. All the research shows that jurors are actually very good at fact-finding, and that's really what their role is. So there is a difference, because arguments to lawyers are going to be to juries are going to be much more about analysing evidence and saying why this evidence should be preferred over that, or why this sequence of events leads to that conclusion, in a much more sort of often a fact-based thing, or what we might call an argument that's got the law embedded in it rather than the law teased out explicitly and then the facts applied to it. Arguments to a judge can often assume a fair bit of knowledge that you can't necessarily assume with a juror, and they tend to be a lot more on integrated law and fact, or more teasing out of the law, and then the fact part probably doesn't need as much arguing as to why one should be done, why one bit of evidence should be preferred over another, because the analysis beforehand has already made that clear. I don't think, though, that, having said that, I don't think we should underestimate the collective intelligence of juries. It's really interesting to sort of have the sensitivity meter going for when people are being patronising or when they're being a bit clever, when they're just skimming over some facts or saying something that's not quite accurate, and seeing how quickly jurors pick up on that. And so I think it's not a question of juries not being smart. It's a question of a different skill set and a different process of decision making. In a sense, there may not be that much difference between addressing a court in a purely fact-based case where the law is not particularly contentious. So, for example, in even in a case where, say, a sexual assault case where the only issue is whether it happened or not. No doubt that if the conduct occurred as the complainant said it did, it's a sexual assault. The question is simply whether she's credible, whether she can be believed on what she said happened. That's a fact-based argument, and there should not be that much difference in the way the evidence is analysed and argued before a judge or a jury. But if you're looking at a case that's a combination of some law and some factual issues, the structure of the argument is going to be different, and the way it's pitched, because you can assume a certain amount of knowledge and pre-reading from the judge, is going to be different.
Thank you, Judge. Many of our jurisdictions and our tribunals, particularly in applications or in chambers these days, require submissions to be filed, and you speak to the submissions. Would you have any tips with respect to that art of making the written submission as a prelude to the oral advocacy?
Yeah. The first thing I want to say is there's no point simply reading a written submission. It's a waste of the opportunity for the oral advocacy simply to read what you've already put. It's also not particularly helpful if your oral submission doesn't seem to bear much relation to the written submission. It's very helpful if you can cross-reference the oral submission to the written submission, so that the judge who's got the piece of paper in front of them can know what part of the piece of paper they should be looking at, or perhaps making their notes on, so that it relates to it. Judges will often give you some indication as to how well they've read the written submission, and that can help frame too the way you want to make your oral submission. But it's really helpful to say, page 1 sets out the procedural history, and unless Your Honour wants me to go through that, that's just there to help frame it. What I want to go to is the primary argument, which is set out on page 2. So you're doing your cross-referring, but then you find a way of arguing it that's different from, consistent with, but different from the way it's in the written submission. And just thinking about the difference in the way people take in information orally compared to the way they take it in when they read it. So maybe a good test is thinking about the oral presentation, thinking about how you can encapsulate in a few sentences what the essence of the argument really is. The written argument can set it out in some detail, and so set out the facts and the law in the sort of detail you need. The oral argument may be able to assume that knowledge and therefore say, the effect of this is A, B and C. So you're getting your conclusionary part. On the other hand, if courts require a no longer than two-page outline of submission, then it's going to be reversed, isn't it? Your oral submission's likely to be longer, but you say, what I'm going to deal with first is what's under paragraph 2, the 3 bullet points there. The contention that I make ultimately is this, and that's set out under bullet point 2. The reason why I say that is the finding the court should make is, and then you develop your oral argument to support that contention. So it is going to vary a bit on whether you put in a full written submission and then you have short oral argument, or whether you confine to a short written submission and therefore the oral argument is designed to tease it out. What is important though, and fundamental to both, is the oral has to be different, otherwise you're just not taking advantage of the opportunity to have a second go.
Are there any questions from the floor at this stage?
Don't be frightened, I'm not that scary.
Yes.
I'll be brave. I quite like being a lawyer, but sometimes I don't like the way lawyers speak. In particular, this whole old-fashioned concept of you're appearing in court and you stand up and you say, "Oh, may it please the court, my surname is this." Is that really, I don't know, relevant anymore? Or is it perfectly fine to just say, "Good morning, Your Honour, my name is blah"? But I just find that I feel like lawyers are a bunch of sheep, and I just constantly hear it over and over again. I'm not really a fan of it because I just feel like it's 2019 and we should really just get to the point and get rid of all of these old-fashioned phrases and things that are commonly used. What was your thoughts on that?
It's a really good question because there's a lot of slavish copying and doing things just for the sake of it. In the advocacy world, again, one of our great bugbears is prefacing questions in cross-examination with, "I put it to you." I don't know who first said it. I suspect it was some remittance man sent out to Australia who'd not had a great success, either as a citizen or a advocate in the UK, and they were sent out to Australia and thought it sounded good, and because it was English, everybody followed it. I don't know. It's just my mad theorising. But people say it because they've always seen people do it. The same with structures of arguments, they say, because that's the way it's always been done. It's really good to say, why are we doing this, and do we need to do it? Is it necessary? Is it effective? I think there's a difference between what might be called etiquette or manners in court and forms of language that have slipped in, like "I put it to you." There's two schools of thought about the good morning. Some people like it because it's more contemporary. Others think that it's inappropriate to the formality of the occasion. There was a New South Wales Court of Appeal case a few years ago where a litigant complained that made a reasonable apprehension of bias argument because every morning counsel for the other side would say, "Good morning, Your Honour," and the judge would say good morning to him. This was what the self-represented litigant on the other side argued in the Court of Appeal. And the judge never said good morning to me. It was like there was a club between the judge and the barrister and I was left out, was the argument. Court of Appeal said, look, a greeting is inappropriate, it's a formal occasion, and if there is to be a greeting, it's got to be to everybody. And I used to sort of bounce into court some days, on my good days, and say, "Good morning, everyone," to try and make them smile instead of snarl. I stopped doing it after I read that New South Wales case because I thought, whilst I had a purpose in doing it, of trying to relax everyone and make them behave, it may have sounded too pally or too informal. And unfortunately, I think while some changes can be made by the advocates, some changes need to be made only with the consent of at the initiation of the court. Legal Latin is something I think everybody should get rid of if they're still using it. And it's... I'll tell a self-anecdote. I know I shouldn't, but I will. I was appearing as what we used to call amicus in a case in the High Court. And I thought, I'm not going to use the Latin. And so I stood up and I announced my appearance as a friend of the court on behalf of the organisation I was representing. And I saw the judges sort of look and then smile because they understood what I was doing, because the High Court isn't that keen on legal Latin, hasn't been for a long time. But it was just a way of all of us realising there was an old convention that had been challenged and it didn't matter. May it please the court still is the customary form of greeting, and unless the court initiates the change, or unless a discussion is initiated, say, between the Law Society and the Chief Justice or the Chief Judge as to whether that's appropriate, I think you probably still need to do it.
Are there any other
But
questions?
you could actually simply, without the may it please the court, I see nothing wrong with simply announcing your appearance and saying, I appear for the plaintiff. You probably don't need this may it please the court and would you be so kind as, but just I appear for the plaintiff. I don't know why in Queensland everybody has to say, may it please the court, my name is Hampel, initial F. I mean, surely you can give a little note to the person who does the transcript and you don't have to say that every time. So why not just make sure they've got your name and then simply say, I appear for the plaintiff. Try it. Try it. Be brave, try that. Don't try the good morning necessarily.
Are there any other questions?
Your Honour, you just touched briefly on self-represented litigants. I wondered if there was any thoughts you could share on the same.
I've just spent 12 months sitting at VCAT, our QCAT equivalent, as a vice president. Tribunals have huge numbers of self-represented litigants. And we've had recently, our Court of Appeal has delivered a couple of terrific decisions. As a decision maker, I think they're terrific because they've taken the law beyond the obligation of a court or the obligation of an opponent to deal with a self-represented litigant springs from the sense that all SRLs are people who are deeply at sea in litigation. We know that many self-represented litigants aren't deeply at sea. They've chosen to be self-represented when representation might otherwise have been available, or they're people with deep senses of grievance about things that have happened and are serial litigants. They require different treatment, or they're just angry and abusive in the court process and won't accept the rules. Our Court of Appeal has laid down these fantastic explanation of the range of self-represented litigants and said the quality of what's required to give procedural fairness is going to vary depending on the sort of self-represented litigant they are. The person who is in desperately need of assistance and at sea needs to be helped. The person who won't accept a court ruling, who is a serial litigant, well versed in procedure, doesn't need the same sort of help and can be shut down if they won't accept rulings, and even removed from a hearing if they won't accept rulings and obey the rules. So you set the boundaries and then you can actually take action without ultimately giving them the right to be heard if they're not prepared to play by the rules. They're great cases to look at because they're really helpful in terms of what those opposed to the self-represented litigant can do and what you can encourage your judge or tribunal member who's dealing with them to do in terms of making sure the hearing is fair for the person who's paying for representation in what can often become a protracted hearing, as well as the self-represented litigant. But essentially, you've got to remember they're not lawyers, they don't know the rules, they need a lot more latitude in terms of making sure they've got the documents, making sure they know the procedure, making sure that there's not shorthand, legal shorthand used between the lawyer and the tribunal member that can make them feel excluded. Down at VCAT, I had somebody who talked, not only kept on saying, oh, we're ad idem, Your Honour. I was saying, what he means is we both agree that that's the right course to take. So every time I used Latin, I'd translate it. And he kept on using it and I kept on translating it. And at one stage he said, and after what's fallen from Your Honour's lips, meaning he agreed with what I said. So I said, again, I had to explain it to this man who had a deep sense of grievance already about what had happened and about the conduct of the represented party. And I just wished I could have taken the barrister aside and said, this is not actually the most appropriate way of dealing with this self-represented litigant. A little bit of not pretending you're in the club with me and a bit more of just telling me what the case is about and what you say should be the plan of action from now on would have been much more helpful. So
why can't the judge then say that to the barrister?
I didn't do it as bluntly as that, but my associate said I was direct. No, but I did say after the third correction of the Latin, I don't use legal Latin and I don't think it's appropriate in this forum to do it. I thought he'd pick up when I translated it each time. He obviously had a different view about it, and the parties had been at loggerheads. It was a deeply bitter relationship, and he was obviously projecting that. But I just kept on saying, we've got to make sure they understand what's going on, and we've got to use language appropriate to that. So I tried to do it that way rather than rebuke, because again, I didn't want either party to go away thinking, I had a victory because the judge got cross with this person, or the other way around. So there's other things you try and juggle at the same time.
Would you please again thank Her Honour for her presentation? And I would like to ask the President once again to close this evening.
So this is the third time you've heard from me tonight. When I took up the presidency a second time, I asked the question, can a souffle rise twice? Well, here's proof that a souffle can rise 3 times. The first lesson, the most primary lesson I learnt in becoming the president was never get between a lawyer and a drink. And can I tell you, one of the most valuable things that you'll get from tonight is an opportunity to talk to each other and perhaps take away some learnings. So thank you very much, everybody, for coming. I think it's been an entirely entertaining, educative and absolutely fascinating session of the Modern Advocate Lecture Series. So thank you very much for coming. And can I ask you all not merely to thank Your Honour, but to thank yourselves for coming. Please, some applause. Please join us in the membership lounge outside for drinks and for some conviviality.